Assalamualaikum warahmatullahi wabarakatuh. This is part 6 for our Zoom recorded lecture for the topic consideration. Inshallah is going to be the final part for the topic. If you notice, the topic consideration is quite bulky because it contains a number of subtopics to be discussed or to be covered. Okay, the last part of the topic will be covering on the areas of exceptions, basically. Here we are going to focus on the exceptions to invalidity of agreements without consideration under Contracts Act. The focus is on section 26. We are going to have a look at section 26 and then the rule, okay, and also the case law, okay, to illustrate the application of the section. So agreement without consideration is void, obviously. Okay, there must be consideration. But in some exceptional situation, even though agreement was without consideration, it is considered as valid. So let's have a look at the circumstances or the situations. The first one, okay, whenever they involve natural love and affection. So this is taken from section 26A as well as illustration B. Let's have a look at illustration B of 26. Okay, section 26 here. Sorry, 26. Okay, 26 here. Okay, illustration B. Okay, 26. All right, here. Okay, A. Okay, agreement made without consideration is void unless it is in writing and registered, and it is expressed in writing, registered under the law for the time being in force, okay, and is made on account of natural love and affection between whom? Between parties standing in near relation to each other. So example is illustration B. A, for natural love and affection, promises to give his son, so it's from father to son, B, 1,000 ringgit Malaysia. And A puts his promise to be into writing. And A, the father, registers the promise under a law for the time being in force for registration of such a document. So is this a contract? Even though B, the son, doesn't give any consideration towards A, yes, this is a contract and it is valid and enforceable by virtue of section 26A. Okay. Go back to the slides. Let's have a look at the later case law. Okay, so from the section just now, we can extract the requirements. Okay, what are the requirements under section 26A? Okay, first, it has to be in writing. So oral agreement is not good. I mean, it won't fulfill the requirements under section 26A. And then wherever required, applicable, it has to be registered. And then another requirement in connection to the, in relation to the position of the parties. Okay, the parties stand in their relation to each other. There are someone who are near to each other. It cannot be any strangers or it cannot be far away. Relation. So the requirements regards to relationship between the parties, between the promisor and the promisee. Let's have a look at the case law. Re Tan So Sim. Re is in the matter of. Okay, Tan So Sim, reported in 1951. The deceased was Tan So Sim. So she had 3 sisters, and their mother, okay, was firstly married to one Koo, and they had 7 children. And when Koo died, okay, she married Tan So Sim's father, okay, and had 4 daughters. So mean that here, different children from different father lah here, okay, 2 fathers. So Tan and Koo's children maintain social and friendly relations with one another. Mean that here they have good relationship. And Tan So Sim, the mother, married again, and then no children, okay, having no issue. And then they adopted 4 children. So many children involved here. Okay, and her husband also married a second wife. Okay, because those days, Chinese, they were allowed to take second wife legally. Okay, it's polygamous. And then because Tan So Sim had, wealthy, had certain wealth here. So when Tan So Sim was on her deathbed, okay, now she was too ill. She was too ill to make a will. So all the Koo and Tan children, okay, signed a document. They prepared a document, and it was drafted, okay, drawn up by a solicitor, renouncing, okay, leaving, going all claims to Tan's estate in favor of 4 adopted children and Tan Boy Ki, the second wife only. Because Tan So Sim had quite a number of children, but now the document said that okay, the whatever estate, whatever property left, okay, by Tan So Sim will be given to only 4 adopted children and also the daughter, okay, of the second wife, okay. Sorry, and also given to the second wife only. So, and then Tan Boy Ki, the second wife, told them, okay, that this was the testamentary intention of Tan So Sim, the wishes of Tan So Sim, basically. And then later, Tan So Sim died without having recovered consciousness. So now the issue, later the children of Tan So Sim, okay, they challenged the validity of the agreement, of the document. So now the issue before the court was whether the instrument signed was valid, okay, as a contract under Section 26A. And the court, in order to answer the issue here, okay, the court discussed, okay, what's the meaning of the word near relations here? Because it involves certain families, a few families involved here. Okay, the court concluded that Khoo's and Tan children are related to the 4 adopted children. Yes, they are all related, but then are they really near? They are only related in a special and limited way. And in other words, it is not near enough actually here. Okay, and what more, the second wife, okay, Tan Boy Ki's relationship to them is certainly more remote, okay, compared to relationship among children here. So actually, instrument did not fulfill Section 26A, the third requirement, which is parties should stand in near relation. So they have relationship, but then they are not really near, okay, which comes under the requirement of Section 26A just now. We have another case, quite recent, okay, compared to this case. Okay, this case was in the year 1951. We have a case in the year of 1998, Huat Po Guan and Kwek Awang. What happened here? Plaintiff is the administrator, okay, of the estate of one Sit Kibu, okay, that's the deceased, okay. And who was the defendant? Defendant is one of the beneficiaries of the deceased estate. And the deceased possessed one asset, okay, in the lifetime, okay. He or she here possess 1/3 portion of a parcel of a land. I think she. Okay. The dispute is pertaining to ownership of the land. Meaning they are fighting over this land. Okay, 1/3 portion of a land. And then the land was already transferred by the deceased as a mother to the defendant, her son. In the year, only transferred only to one son instead of other children. And then in terms of a requirement of near relationship is between mother and son. So yes, they stand in near relation to each other. So the one who the transfer or the deceased, he was the mother of the defendant, the transferee. And then nothing mentioned. Even though in the form itself, it doesn't, no need to mention, oh, I transfer and then there exists love and affection between the parties here. And then in order to prove that requirement or element, okay, whether or not exists any element of love and affection, the court will look at the evidence, okay, produced or adduced by the parties and also the surrounding circumstances. So yes, the transfer was in consideration of love and affection, okay, from a mother to the son. So it is a gift lah, because the son didn't pay for it, okay. It's one way. It's a giveaway, okay, for free, okay, nothing in return from the son to the mother. And then whenever it involves parent and child, that here the court has a strong presumption that yes, there must exist love and affection between a mother and a son. Any whatever evidence will be sufficient. The court will agree, will accept. Okay, but then this presumption, okay, might diminish, can be rebutted if the relationship is less near. And in order to rebut this presumption, there must be express evidence, okay, to that effect. And then from the evidence, okay, produced by the parties here, okay, it is clear to the court that defendant, actually the son who received the land, okay, from the mother, had assumed greater responsibility towards the care and well-being of his deceased mother as compared to plaintiff and other children. Because meaning that here, other siblings, they were challenging about the act of the mother giving away the land only to one child instead of other children. Because why? It was the defendant, okay, who took care of the mother. Okay, the rest of the children, they didn't care about, they didn't bother about the mother. Okay, so this is clear from the conclusion, okay, by the observation by the court, okay, from the evidence produced by the parties. Okay, so yes, the agreement was valid. So it satisfied all requirements under section 26A. Okay. We have another case, quite recent, and this is judgment by Court of Appeal, Tan Meng Hock and Tan Ming Seng. Okay, here we have a written contract. The defendant, who was the defendant? He was the plaintiff elder brother. So the brother, okay, elder brother agreed to give plaintiff, okay, for love and affection, the cash, okay, in the sum of 60,000 ringgit Malaysia, apartment unit and a piece of land. So this is a way of gift lah. Okay, it's not there's no consideration, okay, from the plaintiff towards the defendant. And then in consideration, okay, plaintiff agreed not to make any further claim against the defendant, okay, or against the estate of their deceased father. And then defendant actually honored his promise here, okay, had given plaintiff the cash, okay, 6,000, and also the apartment. But he didn't want to give the land as promised earlier, okay. And defendant argued that the contract was void because why? It was based on love and affection and without consideration. In the here, oh, whatever promised by me towards you, actually it was void because there's no consideration. Okay. And in order to give judgment, okay, the court actually make all the observation here. Okay, the court said in Malaysia, okay, moral obligation is considered sufficient consideration under section 26A, okay, of Contracts Act. And then you can have a read later. Okay, the court look at the nature of the relation here. Okay, so by right they were biological brothers. Okay, and they stand in near relation. Okay. And then actually, by right, the family arrangement, whatever transaction between them, whatever promises between them, it fulfilled all the requirements under section 26E. Okay? And yes, it was valid and enforceable, even though it was done without consideration. So yes, the court upheld the written agreement, okay, made by the parties here. Okay, another situation. Okay, the first one, love and natural love and affection. Okay, another one, exception, okay, to the general, an act voluntarily done, okay, by the promise. Okay, I mean that here, it's not at the request or the desire of the promisor. So we have illustration C and D. Let's have a look. C and D here. Illustration C. Okay, A finds B's purse and give it to him. Okay, mean that here the acts of finding first, then only comes the promise to pay. B promises to give A 50 ringgit. Okay, 50 ringgit. So is this an enforceable valid contract? Yes, it is. Okay, because the act of A finding B's purse is voluntarily done, so it fulfills the requirements of 26B here. That's another C and D. Okay, illustration D as well. D, A supports B's infant son. Infant usually is underage or baby, okay? Not necessarily baby. So long, it's like minor and major. Okay, infant is minor. And B promises to pay. I mean, here the act of supporting son, okay, taking care of son, was done prior to promise to pay. So B promises to pay A's expenses in so doing. I mean, here the promises, it was done voluntarily. Okay, so is this enforceable contract with valid consideration? Yes, it is. Okay, so it satisfies requirements of section 26B. Okay, provided it is something which is voluntarily done. Okay, we go back to the slides here. We have a case law to explain or to illustrate application of section 26B just now. The case name is J.M. Witherspoon Company Limited and Henry Agency House, 1962. What happened was that a defendant's firm in KL, so the firm made an order, okay, for X company through plaintiff company in London. So they ordered certain confectionery and it was obtained from a Dutch firm in London. And plaintiff shipped and delivered the confectionery to X company. So the order was made for the benefit of some other company, X company, but the order was made by the defendant. And then plaintiff paid the price, okay, for the said confectionery to Dutch company and admitted doing it, okay, at the suggestion of the defendant's firm. So they made the payment first, and then it was done at the suggestion of defendant firm. And later, because X company is supposed to pay, but X company went bankrupt, cannot pay. Okay, whereas payment was already done, okay, by plaintiff. Now, defendant wrote a letter to plaintiff agreeing that if X company defaulted in payment, it will pay the price of the confectionery. Okay, they mean, okay, it's all right, we are going to pay you if something happened to X company. But later, defendant had a change of mind. They did not honor their promise. Okay, defendant refused to pay, and now plaintiff sued to recover the damages. You promised to pay, but now you didn't pay. Now we are asking for you to pay. Okay, asking for compensation. The issue was that whether the defendant's promise to compensate, okay, the plaintiff contained in the said letter, which was without consideration, okay, from the plaintiff, is it a contract under Contracts Ordinance 1950? This one before Contracts Ordinance becomes Act, okay, later. And then the court referred to section 26B, okay, it has to be voluntarily done, okay, a promise to compensate. But as far as the fact was concerned, okay, an act was done, okay, payment to X company was done at the suggestion of another party. So it's not something which is voluntarily. So here, I mean that here it doesn't satisfy requirements of section 26B. Okay, it wasn't done voluntarily. If you want to prove it, it was done voluntarily, then prove it. There's no suggestion by some other party or person here. Okay, so it won't fulfill requirements under section 26B because it was done at the suggestion of another party here. So claim failed under section 26B. And then for 26C, okay, the third circumstance, okay, a promise without consideration by a debtor. Okay, let's have a look at illustration E first before we go to the slides again. Here, right? Okay, here. A owes B, so A is the debtor, B is the creditor. A owes B 1,000 ringgit Malaysia, but the debt is brought by limitation. Okay, what's the meaning here? We are going to have a look at the slides again later. And then A signs a written promise to pay B 500 ringgit Malaysia on account of the debt. So is this a contract? Because they have a proper written document here? Yes, it is. Okay, and it satisfies the requirement of section 26C. Okay, let's have a look at 26C here. The slides. So a promise to pay a debt barred by limitation of law. Okay, so we are going to cross-refer to the act related to limitation of law here. Is valid even though there was no consideration, okay, provided that the promise is in writing. And then it was signed by the promisee or his agent. So we cross-refer to Limitation Act 1953, especially Section 6. Okay, what's the limitation? I mean, how many years? Okay, it amounts to limitation here. Actually, in Malaysia, period is 6 years. Okay, so if beyond 6 years, then it is considered as debt barred by limitation law. You cannot ask for your debt to be paid after 6 years lah, basically here. But if okay, it is done, I mean, if the parties agree and then they promise in writing and they sign, okay, the promises sign the document, then yes, it is still enforceable despite the debt barred by limitation of law. Okay, so this is another exception. You don't have case law, so it's quite straightforward. So we just rely on illustration E and we cross-refer to Limitation Act 1953. The last one, okay. The last one is not contained in section 26, but it is under section 4C, Contracts Amendment Act 1976. So it relates to specifically, to government scholarship agreement. So it is not void for lack of consideration. If you were to go to Contracts Act here, section 4C actually at the end of the section here, because it is amendment part. So you scroll down. Okay, so the last section will be section 191, and then you have here Contracts Amendment Act 1976, and then we have section 4. Okay, it talk about validity of scholarship agreement. Okay, notwithstanding anything to the contrary, okay, no scholarship agreement shall be invalidated on the ground that C, okay, such agreement lacks consideration. Now here, even though it is lacks of consideration, then it is still valid. Okay, whenever it relates to government scholarship agreement. Okay, go to the slides. We have the case. We have the case actually. Okay, here. The case is University of Malaya, UM, and Lee Ming Chong, 1986. Let's have a look at the facts here. I have prepared a summary. It started with here, okay? A scholarship agreement, okay, was entered into on July 26, 1964, between whom? Lee. Okay, Lee is the one who received the scholarship and also the university. And there were also two sureties or guarantor, okay, for Lee here. And what's the content of the agreement? The agreement provided that, among other things here, inter alia, that if required by the university, okay, Lee, upon his return, okay, after he completed his study, okay, will serve the university for a period of not less than 5 years from the date of his first appointment. And a breach of this term, okay, without the consent of the university, will render Lee and his sureties liable to pay, okay, the university on demand of a sum of $5,000 here, okay. And then on his return, I mean here after he completed his study, so Lee rejoined the university. Lee was appointed as assistant lecturer, and this service contract was to expire on 1st January 1969, okay, 5 years basically. And in letter by the university dated July 9, 1968, okay, Lee was confirmed in his appointment as a lecturer, okay, with effect from 1st February 1969. And then Lee didn't want to serve, so Lee declined the offer and he gave notice of his intention to terminate his service with the university. Okay, and then he write a letter lah, basically. And university didn't agree, okay, didn't allow the plan or the whatever intention by Lee here. So university demand the sum 5,000, okay, to be paid in accordance with the scholarship agreement, because he had only been in service for 2.5 years, okay, whereas he's supposed to 2.5. Sorry about the figure there, okay, it's not 21 2 here, is 2.5, okay. Yes, and that he was leaving the university without university consent. So now university was suing him. The university brought action at the session court against Lee, asking for the amount of $5,000, okay, for breach of undertaking in scholarship agreement to serve university, okay, because Lee is supposed to serve university not less than 5 years, but he only served 2.5 years, and then he decided to terminate or to leave the university. And then in his statement of defense, okay, so Lee actually argued or contended that, okay, university entered into the scholarship, agreement as an agent, okay, and then on behalf of Canadian, we skip number 1, not really relevant to the topic consideration, but we focus on number 2. Our second argument here, scholarship agreement was void because why? It was made without consideration. Okay, that's the argument, okay, by Lee here, scholarship recipient. And the court allowing the appeal, okay, by the university, okay, the court held that actually, if you look further, okay, there was consideration, okay, on the part of the university. The fact that university appointed him, okay, to the scholarship, okay, was the consideration on its part for his promise to serve it for 5 years after completing the course. So there was exchange of the role or task here, promises here, okay. And the court said, well, let's say, okay, we decided that there was no consideration. We can apply Section 4, okay, because Section 4 Contracts Amendment Act 1976, it provides that notwithstanding anything to the contrary contained in the Contracts Act, okay, no scholarship agreement shall be invalidated on the ground that it lacks consideration. But the court held there was consideration. Even if there was no consideration, it was still valid and enforceable by virtue of Section 4 of Contracts Amendment Act 1976. So that's it for the topic.